Dear all, let us discuss some of the different business models that is available before under the Indian scenario. We have, while starting an industry, we have an option to start an establishment as a proprietary concern, that is we call as sole proprietorship. The difficulty or the advantage of a sole proprietorship firm is the liability of the sole proprietor is unlimited, whereas for him it is very easy to start a business. But when you approach a bank for a loan, you will have difficulty in getting a sanction for the loan because you are operating your business under a sole proprietorship firm. There is no law governing a sole proprietary firm. You can start your own proprietary firm without any kind of registration. That doesn't mean the other laws doesn't apply. You may be a proprietary firm, your own, but if you are employing 20 or more employees and if you are employing 10 or more employees with using the power and where the manufacturing activity is carried on, the Factories Act will apply. So naturally you'll have to take a registration of the Factories Act. If you are an office, you will have to take a registration under the Kerala Shops and Commercial Establishments Act. What I am trying to emphasize is the various models of business. The one is sole proprietorship firm. The second is partnership firm. When you start a business, you can have a partner. Minimum number of partnership is 2 and above. In the case of banking establishment, the limit is 10. And all other establishment other than banking, you can have a partnership of 20 up to 20 partners. So partnership firm is an association of partners where the terms and conditions are agreed upon, the money invested in the partnership firm, and the profit and share of the establishment, the books of accounts, the dissolution of the partnership deed in the event of death of a partner, and how to induct a new partner, etc. So partnership is an association of one or more individuals to start a business. That is another form of business form. Partnership Act the Partnership Act is governed by the Indian Partnership Act of 1932. But the Act doesn't stipulate that all partnerships should be registered under the Indian Partnership Act. Even an unregistered partnership will have all the legal validity. But for the purpose of more effective implementation, most of the partnership firm will get a registration under the respective registrar of the respective state governments. That is called a registered partnership firm. That is, first is a sole proprietorship firm, the second is a partnership firm, third is a company. When I talk about company, there are ever so many types and categories of company. The simple basic is, the company is the one-person company, what you call as OPC. You being a single person, you can register a company under the Registrar of Companies, under the Ministry of Corporate Affairs, that is called MCA. All the companies are registered under the Ministry of Corporate Affairs, and a non-man company, that is called OPC company, where you require only one person, a single person, but it is a company. The advantage of one-person company is the liability is not limited to the assets of the company. The liability is limited only to the assets of the company and not to the personal assets of myself. In the case of proprietorship firm and partnership firm, Any liability on the side of the proprietor or the partners, the liability is not limited to the asset of the partnership firm or proprietorship respectively. Even your personal property can be attached if there is a debt on the side of the partners or proprietor. So we tend to register a company under the Indian Companies Act. To begin with, one man, one person company is a basic simple company where a single person can start a company, business operation. The number one objective is the liability is limited. Unlike a proprietorship or partnership firm. Under the Companies Act, you can have LLC, Limited Liability Company. What is Limited Liability Company? 2008, when the economy was opened up, as in the case of other developed countries, India has also adopted a form of limited liability company, partnership. It is called LLP, Limited Liability Partnership. You can register the Limited Liability Partnership with the Registrar of Companies under the Ministry of Corporate Affairs. So you need to have only 2 persons basically to form an LLP company. So you ask a basic question, what is the purpose of registering an LLP under the company's corporate affairs? The reason is the procedure is slightly simple than that of the registration of the company as that of a private limited company or in the case of a public limited company. So that is the advantage of registering now an LLP. The procedure is simple. The filing of the returns before the registrar of companies is simple. Your tax liability is going to be simple. Your winding up procedure is going to be simple. Whereas your process of registration is also going to be simple. So the LLP registration, wherein the liability here also is limited to the assets of the LLP alone. Another type of company is Section 8 company under the Indian Companies Act of 1913. When I talk about the Section 88 company under the Companies Act, earlier it was called Section 25 company under the old Companies Act of 1956. That was replaced by the amendment of 2013 of the Companies Act, Section 8 of the Companies Act, where it is called a company with the object of achieving the charitable, philanthropic and such kind of activities where the object is charitable in nature. For example, Section 18 company is Infosys Foundation, is a company registered under the Section 8 of the Companies Act. Then another is Reliance Foundation, Tata's Foundation, Tata Group of Companies. So these are the purpose and object of the Section 8 company registration is you will get exemption under the Income Tax Act provided you apply for exemption before the Income Tax Commission under Section 12A of the Income Tax Act of 1961, and you can claim benefit under Section 80G of the Income Tax Act. So not necessary all companies registered under the Section 8 will get an exemption, but your books of account should prove before the Income Tax Authority that your major source of income is used for the purpose of philanthropic or charitable service, then only you will get an exemption under that. So apart from that, there is another company which is called private limited company, where you can have 2 or more shareholders. The private limited company should have 2 or more shareholders having minimum 2 directors, whereas the public limited company is having more than 2 with unlimited directorship. Let us conclude these types of different models of business establishments, and on another session we will have furthermore details on further business models. Thank you very much for watching this video.